Thank you, Your Honor.
Mr. Walgren, thank you. Mr. Flanagan, recross.
Nothing further, Your Honor.
May Dr. Schaefer be excused, Mr. Walgren?
Yes, Your Honor.
Mr. Flanagan?
Yes, Your Honor.
Dr. Schaefer, thank you again. Please remember the prior admonishments. You are excused. May I see counsel?
refining a stipulation, which the parties are going to present in just a few moments. So if you wouldn't mind, just give us a few. One of the reasons I request that the attorneys refine a stipulation and make sure that they can reduce it to writing is that frequently when you have one side stipulating, the other side will say, well, how about changing this word? How about changing this word? So we want to try to have it finalized. Is there a final stipulation?
There is, Your Honor.
You may read it.
And this relates to People's Exhibit 52 that may not have been seen for some time, but the stipulation is that People's Exhibit 52 accurately reflects the phone numbers and the names associated with each phone number.
Do the people so stipulate?
Yes, Your Honor.
Does the defense stipulate?
We do.
Thank you. Do you want that stipulation memorialized as 249? I would encourage you to have it written, please.
Yes. How about 52A, Your Honor, since it's associated with that exhibit? Is that okay?
Is that okay with the defense?
Yes, it is.
That stipulation in written form is marked 52A. It's stipulated by the people.
Yes, Your Honor.
By the defense.
It is.
Once again, it's accepted by the court. So 52 accurately reflects the phone number information. 52A and 52 reflect that. Once again, are there any additional witnesses or any additional evidence to be presented by the people, Mr. Walgan?
No, Your Honor.
The people rest their case.
Yes, subject to receipt.
Thank you.
Of exhibits.
And subject to receipt of exhibits, Mr. Chernoff, are there any additional witnesses or evidence on behalf of the defense?
No, Judge.
And subject to receipt and to evidence of exhibits, the defense rests its case.
Yes.
Thank you. Ladies and gentlemen, You've seen and heard all of the evidence in this case. When next we meet, I'll be providing you with the list of exhibits, because it's tough trying to follow them, even though you're way ahead of me when it comes to that. But we'll have for you an exhibit list of any and all of the exhibits that actually have been received in evidence in this case. The attorneys have requested that I provide them with a reasonable amount of time in order to prepare their arguments, and that request certainly is a reasonable one. What we're going to be doing outside of your presence is discussing the all-important jury instructions which you will receive, and making a determination of the actual exhibits that have been received in evidence. Those are matters that don't need your attention. Those are matters particularly within our responsibility as the court and as the attorneys. What we're going to do is we're going to excuse you until this coming Thursday at 9:00 a.m. The attorneys and I will be discussing in the interim the exhibits and the jury instructions, and the attorneys will be presenting their arguments, so your services aren't required. So we will be in recess on this case until 9 a.m. this coming Thursday, the 3rd of November, 2011. So please bear in mind, and of course follow unhesitatingly, all of these admonishments. Do not discuss this case among yourselves or with anyone else, or form or express any opinions about the case until it is submitted finally to you. Do not visit any scene or location that may have been referenced, mentioned, or involved in the case. Don't perform any experiments, or on your own or through another person, conduct any independent research or investigation on any topics, subjects, or persons mentioned or involved in this case. Do not listen to, see, or hear any television or radio programs, newspaper or magazine articles, books, or the Internet regarding any of these topics or subjects or persons. Have no contact with any of these information sources. Do not access, on your own or through another person, any Internet website, including but not limited to any social networking site, such as MySpace or Facebook, or any information website, such as Google, Ask, or Bing, or text or tweet anything about the case, or access any blogs or post any messages on any sites whatsoever. Do not have any contact or communication by any electronic communication device, including but not limited to any cell phone. Do not come in contact or have any communication with the defendant, the attorneys, the witnesses, or spectators. If anyone contacts you or tries to contact you in any way, either in person, in writing, by telephone, by email, by cell phone, post any messages on any of those types of devices, immediately cease any such encounter or contact and immediately notify the court staff. Do all of you continue to assure and promise us that you will follow not only the written admonishments which I gave to each of you, but also my continuing verbal admonishments, all indicating in the affirmative. Ladies and gentlemen, we're going to ask that you join us this coming Thursday, the 3rd of November, 2011, at 9 a.m. for further proceedings in this case. Have a good day to get back to all important work responsibilities and personal responsibilities, and we'll see you on Thursday morning. Good day. Thank you.